Hi, this is Alan Gassman. I'm here to talk about creditor protection from A to Z. I apologize for the late start. I'm thrilled to be here and thrilled that you waited a few minutes for me to get started. So the biggest question I'm getting today is, what does the new infrastructure bill do to my taxes? And the answer, to the extent that I can find out, is it's not going to do anything to your taxes in the short run. There is no tax legislation that I'm aware of connected to this bill. This bill was going to have the corporate minimum tax of 15% as part of it, but they were not able to get the votes in the House for that. This passed last night with 9 Republican congressmen supporting it. I don't think they would have supported any tax increases. So what you have is about $260 billion of COVID-19 relief money from the PPP program, the Restaurant Relief Program, and the EIDL program. Those were instead going to be spent now here instead of being refunded to the Treasury. Otherwise, the expenses here are all being handled on a go-forward basis. So your increase in taxes will happen someday, but not as the result of this new act. Now, we do publish a Thursday report. It is absolutely free and almost worth it. So you can go, if anything you want to search on taxes and planning, actually Google Gassman Thursday report, and whatever the topic is, Florida Homestead, creditor protection, PPP forgiveness, chances are we have covered it on a Thursday report. So enjoy that. We also have a YouTube video collection, and one whole part of the collection is estate tax planning, and that's where we'll probably be reposting this today. Then we have a charitable section, and then we have an asset protection section. So you can go to our YouTube video and check that out. The second most important question I'm asked is, what is going on with the Build Back Better Act, also known as the Tax the Wealthy Act? And the Democrats are still going back and forth with one another, as friends often do, as family often does, including those family members that you know who you don't speak with. You know that. So that's what's going on. But based upon what was released this week, I believe it was on Wednesday. In fact, I'm sure it was on Wednesday evening. Here is what they thought would sell to all 50 Democratic senators. If your modified adjusted gross income is in excess of $10 million, and that includes capital gains, and that does not allow you to deduct what you would normally deduct from income. If you're in excess of that 10 million, 5% surtax. So you thought that your capital gain was going to be based upon a 20% capital gains rate, maybe a 23.8% capital gains rate. Well, now if you have a nice big hit, you're going to be not at 23.8, at 28.8. And that's coincidental because during the Reagan years, capital gains at one point were taxed at 28%. Okay, now if you're over 25 million, then I'm going to give you my cell phone. You can call me anytime you want. And there's an extra 3% surtax. So, and it appears that these surtaxes are based upon whether you're married or single. So, you know, you could get a divorce. If you have 20 million of adjusted gross income, go ahead and get a divorce, and then you each receive 10 million and you have no 5% tax. So that's going to make divorces much more popular among the wealthy. Then the other thing that's going to hit a lot of people, a lot of you who are listening and watching, is the net investment income tax under Code Section 1411. It is a 3.8% tax, and many, many, many Americans, including Joe Biden, I understand, have what we call S corporations, and the S corporations would pay a reasonable compensation amount, what you're actually worth, and then all the other income beyond what you're worth as a worker comes to you as dividends and is not subject to the net investment income tax under section 1411. So guess what? That exemption is going to be over if you're single and you have more than $400,000 a year in MAGI, modified adjusted gross income, or if you're married and have more than 500,000, then you're going to pay that 3.8% tax. So if you have 800,000 of modified adjusted gross income, you can go ahead and get divorced, and then each spouse will have 400,000, and neither of you will get hit with this 3.8% tax. But if you have $1 million of K-1 income from S corporations, it's going to cost you an extra $38,000 a year, payable to the largest charitable organization in the world, the United States government, but unfortunately not tax deductible. Now, cryptocurrencies are going to be subject to constructive and wash sales rules. So if you have cryptocurrencies that have gone up in value before this act comes into effect, you would want to go ahead and sell them using if you have offset losses that you can take. And then you can immediately, at the same time you sell them, buy something substantially equivalent and use your capital losses against that. Very, very exciting stuff. Then the alternate minimum tax on large corporations. This is going to cause the value of large corporations to go down a little bit if they're going to have to start paying taxes, and that could affect their price on the stock exchange. I don't know that there's been any adjustment yet going on. The other opportunity that would become limited is if you have a C corporation, which is also known as a 1202 qualified small business company, and you have AGI exceeding 400,000, then your 100% exclusion from the sale of that stock will no longer be 100% exclusion, it will be a 50% exclusion. Then if you have a $10 million IRA, you'll have terrible issues beginning in 2029. So make sure you call us in early 2028. I'm not going to worry about this yet, other than to say that if you're very generous and you have a large IRA and you're over 59 and a half, you can withdraw as much as you want from that IRA and give that money to a private operating foundation that your family can control, and you will never pay tax on that IRA. You'll get 100% deduction for putting that money in the private operating foundation. So if you are involved with charities and you have donors who give $100,000 a year from their IRA because they're over 70 and a half, they can go unlimited this year. Keep that in mind. That's not going to be changed by this new rule. Now, what Bernie Sanders really got upset with was they would begin to allow taxpayers to deduct more than $10,000 of property taxes as itemized deductions. It would be $72,500. And if you divorce your spouse, then you'll together have $145,000 in property tax, sales tax deductions against your federal return. So this, we don't know where this is going to end up. Everything I'm talking about here is speculative, but it is in the 900-page bill that was proposed on Thursday that apparently the White House thought had a chance of passing or was getting very ready to pass. The other thing is the $79 billion allocated to the IRS. So every state on average will get an extra $1 billion to employ and educate IRS auditors, hopefully to give better service when we have questions, to do a better job collecting from people who actually owe the taxes, and of course, to come and audit all our clients so that we can represent the clients and make a lot of legal fees. That would not be a happy event for us or for anyone, but that would be the best money spent from the government standpoint, because if they spend $79 million and staff up the IRS, they'll definitely get more than $79 million in tax receipts. The last thing is they continue to try to close the door on the ability of a U.S. taxpayer to set up an offshore company that will be taxable at the 0% bracket on its foreign income and certain US-based income that goes into that foreign entity. And then you don't pay tax on that income that gets stored up in the foreign entity until it is paid to the United States. And that is a very legitimate, commonly used strategy that US international companies have a fiduciary duty to do, and that is going to be reduced or eliminated. And many charities set up offshore companies so that income that would otherwise be what we call unrelated business taxable income will be instead not taxable. It would go to a foreign company, and when the foreign company pays a dividend to the charity, that's exempt from the unrelated business income tax. So this may cost charities some money. We will see. But the good news is no estate tax exemption reduction, no gift tax exemption reduction, no assault on grantor trusts. But if you have trusts that are not a grantor trust, a trust that pays tax at its own bracket, then we're going to have some planning to do, because this 3.8% net investment income tax will apply to passive trust income that stores up in a trust that pays its own taxes. The way around the tax will be for the trust to distribute the income to beneficiaries, but then the beneficiaries will then be holding the hot tamale. And if they're over that $150,000 exemption for individuals, $250,000 for married couples, they'll be paying that 3.8% tax on their trust income. Now, I'm not going to go into a significant amount of detail because this is supposed to be asset protection. I shouldn't be here taking all of Brandon's hard-earned slides, which he worked on all day and all night, and showing them to you, but I am. So if you are in the middle of corporate planning, whether you're a C corporation, an S corporation, an LLC, and you're not even sure what you are, you might want to wait a couple of weeks because these rules are very likely to change. And when they do change, it will not be simple. There will be all kinds of implications. But those of you who are tax lawyers and CPAs, you may enjoy using these slides and taking a look at them. They boil down some very, very in-depth David Kirk, Notre Dame Tax Institute presentations. And if you'd like copies of David's materials, I will be glad to send them to you. He is much smarter than I am. More information here on what the definition of modified adjusted gross income is. It is going to be your adjusted gross income reduced by certain deductions, but not others. So it's going to be a big tax on high earners. They're more likely to go out and buy cruise boats and airplanes that they can write off under Section 179 because there's no limitation on that here. If you would like one of our updated estate tax planning spreadsheets, just send me an email, put in the RE line spreadsheet. It's agassman@gassmanpa.com, and Kelsey will send you the spreadsheets, and then you can use them. The spreadsheets are featured on most of our estate tax webinars, at least the last 3 to 4 weeks. So you can go to one of those to see how to use the spreadsheet. A lot of what I'm going to cover today is from the book Gassman and Markham on Florida and federal asset protection law. I thank the co-author, Michael Markham, who has had the pleasure of reading the book 10 to 12 times and explaining things to me. And also contributions in this book by Jonathan Gottman, Steve Oceans, Jonathan Blottmacher, Martin Shinkman, and Al Gomez. I thank them for all their assistance with respect. So anyway, I start here. I enjoy this story. 2016, a lady brings her daughter to Target, and the daughter picks up a hypodermic needle from the parking lot, and the lady batted it out of her daughter's hand and got stuck, went to the emergency room, got a shot, had a bad reaction, sued Target. Target wouldn't pay her. The morning of the settlement, Target had an offer to settle for $12,000, refused to settle. Jury came in with $4.6 million. So Maybe the lady was hurt worse than 12,000, but certainly worse than 750. So that made the news. Now, people say, well, there's no way that I'm going to have a liability that exceeds my $5 million or $10 million or $20 million exemption. Well, what if you own a building that falls on someone's head and they are paralyzed? In this case, that was worth $148 million. Now, that's a little bit more than most people can afford to pay. And these cases do happen. Especially in Western Texas, juries are known to regularly award multi-hundred-million-dollar verdicts. And in Tampa Bay, Florida, we've had several verdicts over $100 million, often medical malpractice, but sometimes car accidents. So these things do happen. Here's a dresser fell on a baby, and IKEA should have known that that dresser was likely to fall on that baby. $46 million. A sad story for that family, and not a good day for IKEA either. Pizza Hut, the $10,800,000 pizza. Well, if you subtract the profit from the pizza, it cost them a little bit less than $10,800,000. So just be careful. The first thing we talk about when we do creditor protection planning, and for most of our estate planning, is who owns your vehicles and who's driving them and why. Please don't drive and text, because first of all, you may kill someone I love, but second of all, you may go to jail for 10 years on manslaughter if you are texting and driving and you kill someone. If you are drinking and driving and you kill someone, you may have a minimum sentence. In fact, in Florida, if you're just over the limit, which is 0.8, which is pretty much a beer and a half, and somebody runs out in front of you, there was no way that you could control this accident. They just run out in front of you. You're going 30 miles an hour in a 35-mile zone. They run out in front of you. They die. You go to prison for 10 years, even if the law enforcement people don't want you to go to prison, even if the judge doesn't want you to go to prison. So use Uber or hire a driver. They're 20, 25 bucks an hour. They'll drive you in your car. They'll get you safe. You won't have to go to prison for life. But don't let your spouse drive your car, especially if your spouse has been drinking or texts. Those are tough, tough situations. The other thing we always say, and even though we always say it when it's already raining, please remember it was not raining when Noah built the ark. Please get your creditor protection done sooner rather than later. So I want to go through some asset protection definitions here first. We have a lot of non-lawyers in the audience, and you have my sympathy trying to keep up with all this, but I'll do the best I can. The debtor is the person who owes money. The creditor is owed the money. The judgment is when the court orders that the payment be made. So I may sign a promissory note to you, and I will owe you $1 million on November 20, and then I don't pay you. Well, you can't come get my stuff. You can't send the sheriff to take my house away. You can't get anything from me until you have a judgment. There are limited exceptions to this for emergency injunctions. So how are you going to get a judgment? Well, you're going to sue me. And how long is it going to take you to get a judgment? Well, in Florida, on a promissory note, it could take a year, year and a half. I don't recall signing that promissory note. Are you sure that's my signature? I don't think I owe you the money because you did something bad to me. I think you were charging me too much interest. We really need to figure out what was going on here. Let's do some depositions and some discovery, and I'm going to countersue you. So there's time. There's time when you find out there's a situation and you haven't been sued. There's some amount of time. When you get sued, there's still some amount of time. So we'll talk about now the definition of a fraudulent transfer. And the fraudulent transfer law is not the same as the law of fraud. If I commit fraud, it means that I've misled you or lied to you to induce you to do something for my benefit and to your disadvantage. That's fraud, and it is a go to jail situation. On the other hand, the concept of the fraudulent transfer dates back to England, the Statute of Elizabeth in the 1500s. And the Statute of Elizabeth said, if you owe the money, we're going to come get your sheep. And if you gave your sheep to somebody else, we're going to get the sheep from them. And that was the fraudulent transfer statute. So most states have adopted the Uniform Fraudulent Transfer Act. And the Uniform Fraudulent Transfer Act has nothing to do with fraud. It says that if you make a transfer to avoid a creditor, and a primary purpose was to avoid the creditor, then the asset can be chased. The person who received the transfer can be chased for the value of the transfer and attorney's fees and costs. But in most states, there's no other penalty. The only penalty in most states is, oops, you got to put it back. So sometimes, even though you may go to some lawyers who will say, you can't transfer this, you may get sued soon. This may be set aside as a fraudulent transfer. That is often not the right strategy. Now, if you are in California or Connecticut, then a lawyer cannot tell you that it's a good idea for you to go hide your assets or for you to transfer your assets. In Florida, I can tell you, I'm a member of the Florida Bar and you're a Floridian. I can tell you, you know what? You're going to have a judgment against you next week. Why don't you give your assets to your son-in-law, and then you're going to tell them you have no assets, and they may be so dumb as to not ask whether you made a transfer. And if they don't ask whether you made a transfer and you've been honest, you don't have any assets, that may actually work. But if it doesn't work, they're coming after your son-in-law for the assets, and they'll get them. And are you and your son-in-law any worse off? Now, that is exaggerated advice, and I would never give that exact advice to somebody. But that type of advice will probably be better for a Floridian than the first advice, which is don't do anything because you can't commit fraud. Now, more definitions. The exempt asset is an asset that a creditor cannot take away. So in Florida, my annuity contract of unlimited value owned by me, my life insurance policy with a cash value, unlimited value owned by me, my homestead up to half an acre within the city limits, up to 160 acres outside of the city limits, owned by me. I own these things, and then my wife and I own bank accounts and brokerage accounts and a company as tenants by the entireties. So you get a judgment, and then after that, I'm in a car accident. Somebody gets hurt terribly, they get a judgment against me. They can't take my annuity, they can't take my life insurance, they can't take my house, they can't reach my half of the tenancy by the entireties property. They need to settle for my life insurance, for my liability insurance limits. Or if they don't, then I will have to file a Chapter 7 bankruptcy. And under Chapter 7 of the Bankruptcy Code, if it is not consumer debt, but it's business debt, and fortunately, thank heaven, the car accident is considered to be business debt, then I can bankrupt it out, keep my exempt assets, and that's what we want to do for clients. One of my objectives when I do an estate plan for a client is to be able to discuss with that client, if you are sued for millions of dollars, here is what you will lose, and here is what you will keep, and here is in the middle ground. And here's what you can do to save it if you work in advance. If you wait until after the creditor situation is already clear, then it's going to be much harder for you to do the planning. A non-exempt asset is an asset that creditors can take. So what is a non-exempt asset? My bank account in my personal name, my law firm ownership interest, which I'm required to own. I can't put that in joint names under Florida law unless Marcia becomes a lawyer. I don't want her to become a lawyer because she might become a divorce lawyer and divorce me. So those are the non-exempt assets. Okay, page 58, bad faith. This has nothing to do with the band blind faith. You email me within 2 minutes of 11:30 a.m. and give me 2 members of the band blind faith, then I will send you a copy of Gassman and Markham on Florida and federal creditor protection law. So that is the band blind faith, which has nothing to do with bad faith. And I once knew somebody named Faith. I would not call her bad faith. In any event, what is bad faith? Bad faith is when a liability insurance carrier, it has a duty to defend you or your client in a matter, and they have the opportunity to settle within policy limits, and they don't. Then it goes to jury trial, and the verdict comes in above your policy limits. And what happens? Well, in Florida, if everything's properly handled, the insurance company has to pay the excess verdict. And I'll give you a common example. Many physicians get referred to us just weeks before a malpractice case. And many of them say, well, I just didn't realize that I should try to protect my assets. I thought everything was going fine because I did nothing wrong in the treatment of this patient. But the patient had a horrendous health problem, which evolved after I started treating this patient. And now I'm understanding that a jury may say that it was my fault. And I only have $250,000 of limits, which is the minimum in Florida. And this could be a $5 million case. What should I do? And I say, has there been an offer by the plaintiff lawyer to settle for $250,000? And quite often the doctor will say, I don't know. Okay, well, let me look at all the paperwork. Let me call the defense lawyer. Oh, look right here. The plaintiff lawyer, just 9 months into the case, offered to settle for $250,000. What happened then? Well, the doctor, now I remember, the doctor remembers, I told him, don't settle this case. I did nothing wrong. This is ridiculous. Okay, well, you don't have a bad faith claim. So now I have to call the plaintiff lawyer. Say, hey, Floyd, you know your case against Dr. Smith? Yeah. Would you mind offering to settle for policy limits again? And normally Floyd will then say, well, is he collectible? Is the doctor collectible? If he's got millions of dollars of assets, I'm not going to volunteer to settle for policy limits. But if you're going to tell me that he's uncollectible, then I'm going to go ahead and offer to settle again for the $250. And maybe the doctor should put in $50. I'll offer to settle for $300. Okay, get the letter from Floyd, and then the doctor writes a letter to the carrier and says, you've got the opportunity to settle this for $250. The offer on the table is $300, but we're very confident that the plaintiff lawyer will settle for $250. If not, the doctor will put the $50 in. So then the carrier takes a closer look at the suit, and 9 times out of 10, that suit gets settled. If the doctor has done his creditor protection planning. If he has not done his creditor protection planning and it waits that long, then it typically does not settle. So that's bad faith. Your defense lawyer is your lawyer, but being paid by the carrier, and doesn't always want to make a big deal out of the bad faith situation. So that defense lawyer may be simply sending a form letter to the client early in the case saying, there may come a time when there would be a situation where this could go over your policy limit. There may be a conflict of interest. You probably should get personal counsel. But a reputable, ethical plaintiff, a defense lawyer will remind the client quite loudly, but you need to know to make sure to stay sensitive to that. because the defense lawyer gets paid more to keep defending, not get it settled. And in the bureaucracy of law and liability and litigation, many times no one takes a really close look at that case until the week before the jury trial, and then they realize, oops, not such a good case to defend. So too much on bad faith, but I hope that plenty of people got the book. You're right, Steve Winwood and Eric Clapton and Ginger Baker. So thank you very much, Larry. Thank you, Michael. Thank you, Jay. Thank you, Joni. And they probably thank Wikipedia, but still they got it to me within the 2 minutes, except David didn't quite make it. All right. By joint and several liability, that is when you are liable for what somebody else does. Vicarious liability is when you are liable for what someone else does. And vicarious liability actually killed a client of mine. I had a very lovely, elderly but healthy widow, and she had a goddaughter who turned out to be a prostitute. So she allowed the goddaughter to set up a business in her name. And it was a flea market jewelry business. And a customer went to this prostitute and gave her jewelry. And allegedly, she earned the jewelry, but the customer wanted the jewelry back and said that this was a scam and sued my client as the owner of the business. And my client got very upset because he was suing for triple damages, and there was $250,000 worth of jewelry involved, so he was suing for $750,000. And she got very upset, and she died. And after she died, her estate had to pay a lot of money. So that is vicarious liability. An example of joint and several liability is a lovely family that came to see me this week where mom and dad and the two children own a hotel, and they own it as general partners in a Florida general partnership, which means they're all liable if somebody dies or gets hurt. So we're converting that general partnership into what we call a limited liability partnership. And then we're going to do something else. You see the definition here of a secured interest. They are going to not only own their hotel under this limited liability partnership, but they are very proud of the fact that there's no debt on the hotel. And they've worked for literally dozens of years to pay that debt off. And then I said, well, you know, all it takes is one person to trip and fall down the stairs, and you could lose the whole hotel. So what we're going to do is they are going to, the hotel's worth about $1.5 million. They are going to have the limited partnership owe them $1.2 million on a promissory note, and then they're going to take a mortgage on the property. So the capitalization of this company is going from 100% ownership, no debt, to 100% ownership, but there's a loan owed to the owners of $1.2 million. Now somebody trips and falls and breaks their neck in the hotel. There's a big verdict over policy limits. There will be a forced sale of the hotel building. The first $1.2 million is going to go to the clients, and everything left over is going to pay the expenses of the hotel. And this hotel has a lot of accounts payable. So at least the plaintiff lawyer here is going to be more likely to settle, because what's at the end of the rainbow is $300,000 of equity as opposed to a $1.5 million free and clear hotel room. Now, a lot of clients say, well, I'm not so worried because if my company gets sued, I'll just set up a new company. Well, they obviously have not read the articles on the doctrine of successor liability. which says that if you have a judgment against ABC Company, and the owners of ABC Company somehow have another company called XYZ Company, and it has the same customers, the same phone number, the same employees, it's even at the same location. Or let's say it's owned by the wife and mother-in-law of the original owner, and it's at a different location, but it has the same employees and it has the same phone number. Well, that's going to be subject to the doctrine of successor liability. So you actually have to be able to file a bankruptcy. You have to, if you are going to have a judgment against a company and you want to start a new company, you're going to have to file a bankruptcy of the old company and then have the new company buy the assets of the old company, including any goodwill, in a bankruptcy approved sale under Section 341 of the Bankruptcy Code. And then the creditors will not be able to reach into the new company. So the moral of that story is, if my clients were in a horrific lawsuit and they couldn't even afford to defend it, then they could go ahead and file a bankruptcy of the company. They could then sell the $300,000 of equity in the hotel to the new company, and then use the $300,000 to defend the suit. And by the time there's a judgment, there won't be anything left in the company because it will all be used on defense costs. I'm involved right now with a lawsuit where the defense costs are well over $1.5 million on a liability policy that reduces with defense costs. So the cost of litigation itself can be crippling. Speaking of crippling, I want to talk about the doctrine of concealment. Now, the doctrine of concealment is a go to jail rule. And the rule is this: if you march into bankruptcy court or you fill out an affidavit under penalty of perjury and you say, I have no assets, but you know, there's that $300,000 that you gave your mother 3 years ago and said, Mom, I need this back when I get it. And if you die, you need to leave it to me. And it's really my money. And here's an email saying that. That is the doctrine of concealment. So when you tell a lawyer, oh yeah, and there's this money my aunt's holding for me. Well, now the lawyer is a conspirator with you and the lawyer has to resign. So, you know, don't conceal your assets. Don't do silly things with your assets. Don't go to Las Vegas with a lot of cash and pretend that you lost it, but really put it in a safe deposit box. Don't do that stuff. It causes people to go to jail. So that is the doctrine of concealment. One of the best books I ever read, and I give away at least 20 to 25 of them a year. During a recession, I give away 50 a year, by Dale Carnegie, written in the 1930s, How to Stop Worrying and Start Living. It should be required reading for every lawyer and every CPA and every MBA because it has so many good practical suggestions on how to stop worrying and start living. So all you have to do is read that book and your quality of life can go up very quickly. So let's go back now to what are the exempt assets? And one way to find out what the exempt assets in your state are is to go to the ACTEC website, the American Council of Trust and the American College of Trust and Estate Planning Council. They have a website that has a very, very good spreadsheet on what the exempt assets are for each state. There are also commercial websites that purport to do this, but I have found that they are not always accurate. So I am normally using the ACTEC website and then checking the actual statutes. But in Florida, we have something that I want to mention, and that is, unlike any other state in the union, our fraudulent transfer statute does not apply to purchasing homestead or paying down a mortgage. So what does that mean? That means that Mr. Havaco, who allegedly almost stole money from Bear Stearns, got in an arbitration, lost a arbitration award, and immediately after the arbitration decision came out, moved to Florida and bought a very valuable home with his money. And of course, he was sued, and the Florida Supreme Court, in I believe it was a unanimous decision, said, sorry, Charlie, but the fraudulent transfer statute of the state of Florida doesn't apply to Homestead because Homestead is protected in the Constitution of Florida. So that's why there's a lot of corporate executives who move down to Naples, Florida. Up to half an acre can easily cost $10 million. Very nice view, by the way. And then it is creditor protected. And that's why Burt Reynolds moved back to Florida when he had creditor problems. Bowie Kuhn, who was the commissioner of baseball, did it. O.J. Simpson is a Floridian. So this law works. But the federal law in 2005 changed. The bankruptcy code now says that if you make a fraudulent transfer into a homestead within 10 years of filing bankruptcy, it will be set aside. So you not only have to move to Florida and buy a big homestead or a valuable homestead, but you have to stay out of bankruptcy. And if you have less than 12 creditors, any one creditor can put you into bankruptcy. So you have to go out and get 12 creditors and make sure that no 3 of them would force you into bankruptcy. But that is the escape route for a lot of people all over the country. It's a very interesting phenomenon. Now, once they get here and they have their valuable home, they can, even though they have bad credit, they can do a federally insured reverse mortgage. And then they can live off of the reverse mortgage, and the home is getting worth less and less as the reverse mortgage gives them more and more payments. And then they wait for that judgment to run out in 20 years, and then they keep the home. So most creditors, we have found, will settle either after that happens or pretty much knowing that it's going to happen. Don't try this at home. Any client who has this type of situation in any state needs to talk to a well-versed lawyer in that state who practices in the bankruptcy court. Those are the lawyers who really have the best understanding of how the creditor rules work. By the way, I have another book on Amazon on what estate planners need to know about bankruptcy. So you can find that on the Amazon library that we have. And if you can tell me who recorded the song "The Wait" just last year or the year before with Ringo Starr in the next minute, and it's 11:48, then I will send you a free copy of the Estate Planner's Guide to Bankruptcy. Now, tenancy by the entireties is protected in Florida. It is often found in other states, but not protected. Florida, Delaware, Wyoming, and Pennsylvania all offer complete protection of tenancy by the entireties assets. That's assets titled in a proper way. It has to be titled very specially between a married couple where only one spouse is liable. And if the client finds themselves in bankruptcy, it may not work if there's debt against the tenancy by the entireties assets. So we always have to be very careful. 529 college savings plans are protected from creditors in many states. One question is, does bankruptcy law apply or does state law apply if and when the debtor goes bankrupt? And the answer is state law normally applies. The bankruptcy code recognizes the ability of every state to decide what creditors can reach assets and what creditors cannot. But no matter what state law says, tenancy by the entireties is protected from creditors, and IRAs are protected from creditors at least up to about $1,400,000 in value, plus whatever part of the IRA came from pension. So again, very complicated stuff. It can be important in many states if you're a wage earner to get an employment agreement in place to prove that what you earn is actually wages. So here is a typical creditor protection plan. This is a single individual. If you are single, then this may interest you, or if you'd like to meet this single individual, I might be able to introduce you. So the IRA and the 401k, great tax planning and creditor proof. Annuity contracts, creditor proof in many states. Life insurance, creditor proof in many states. Wage accounts, creditor proof in some states, at least for some period of time after the wages get there. Then the homestead. Now, a lot of clients come to us and they have more than half an acre. So we may survey off half at the most valuable half acre, make that their homestead, and then put the rest of the property into a real estate limited partnership and give the homestead property easement rights. That's what we often do in Florida. Then you may have a professional practice. That would be a lawyer, an accountant, a CPA, an actuary, an architect. Has to be owned by the individual, but you could have an assignment that it would be transferred to the revocable trust in the event of death to avoid probate. Now, I'm often asked, will the revocable trust that I set up avoid creditors? And the answer is not whatsoever. It could even hurt you in a creditor situation. For example, in Florida, I don't think that annuity contracts or life insurance policies owned by a revocable trust are protected from creditors. Now, what do you do to protect the building, the equipment of the practice, stocks and bonds, and real estate when the person's not married and they don't want to put these assets under an annuity contract because it won't work that way? So this is where charging order protection and asset protection trust protection may come in. What is a charging order? It has nothing to do with electrical current, and it's not even all that interesting. But a charging order is the sole remedy that a creditor can receive if they have a judgment against the majority or minority member of a multiple member LLC. That was a lot of words, wasn't it? What does that mean? That means that if this individual owns 97% of a Florida, Delaware, Wyoming, Nevada, or even New York limited liability company or limited partnership, and 3% is owned by the irrevocable trust for those cute children or nephews and nieces or siblings or parents, then if you get a judgment against this individual and you are in a state that recognizes having charging order protection as the sole remedy, then the creditor cannot reach into the LLC. The creditor cannot take over control of the LLC. The creditor can only get the charging order where the judge says, if and when you ever make a distribution to the living trust, you must give 97% of the distribution to the creditor and 3% to the gifting trust. And we'll be watching you. So it puts you at a stalemate with the creditor. It doesn't put you ahead of the creditor. The creditor can still reach into the LLC to the extent that you take assets out. So it's worthwhile to have and to do, and it can also save estate tax if the gifting trust is properly drafted and has at least half of the voting rights. But it is by no means a complete cure. So what do you do with the other 97%? Well, if you live in an asset protection jurisdiction, and there's 19 of them, most notably Alaska, Delaware, South Dakota, Nevada, many others, then you can form an irrevocable trust that actually can benefit the individual debtor. And by the way, this individual, we're gonna respell this individual's name, because you don't want to misspell a client's name. A client doesn't know if I know anything about the law, but they do know if I can't spell their name right. So anyway, so I could set up an irrevocable trust. The first one I ever did was in the Isle of Man in 1986, when a client from Scotland was an orthopedic surgeon in Florida and didn't want to lose his assets in case he ever got sued. So we set up an asset protection trust in the Isle of Man. We used Trident Trust Company, who's still my favorite offshore trust company. And we set up an irrevocable trust where the client's father had the authority to replace the trust company, and the trust company had the authority to make payments for the client or his mother or his descendants or his future spouse. And then years later, the client unfortunately had a very bad situation where he bought into a number of nursing homes, and they went belly up in the recession, and the creditors did not even attempt to reach the offshore trust, because we were able to show them that it was set up well in advance of a problem. The motivation was malpractice situations. There was no malpractice situation at the time. So that is how I learned about how offshore asset protection trusts worked. Now, the Isle of Man has a 4-year statute. So if you set up an asset protection trust in the Isle of Man and it turns out there is a creditor, and the creditor gets into the trust because they file their lawsuit in the Isle of Man within 4 years, you lose it. Nevis and the Cook Islands have 2-year statutes, and the Belize has a 1-day statute. As long as no one has a judgment against you in Belize on the day you set up the trust, Belize will not allow a creditor into the trust, and the Belizean Supreme Court has upheld at least one verdict indicating no, you can't get into the Belize trust. So they've also prevented the Federal Trade Commission from subpoenaing information from Belize trusts. So that takes it to an extreme. Jonathan Blottmacher helped Alaska write a creditor protection law that is similar to the Isle of Man law back in, I believe, 1991. And then since then, many other jurisdictions have added them. Do they work? That's a great question. Do they work? Well, for the most part, the first thing I'll say is that if I had my choice between being threatened with a charging order against a company, or knowing that the creditor first would have to set aside a Nevada trust and then would only get a charging order, I'm going with Nevada trust. But can I promise that a Florida judge would not say, hey, your client's in Florida, the assets are in Florida, the beneficiaries are in Florida, the creditors in Florida. I don't buy this thing that this is a Nevada trust. So the Florida judge may say the Nevada trust is all wet. Then does the Nevada court have to recognize that Florida judgment under the full faith and credit clause? And believe it or not, even though we've had these trusts in Alaska since 1991, and even after the Great Recession of 2009, we don't have any really good case law. We've got some flippant cases where a judge just says for no reason, yeah, this trust won't stand up. They don't explain why, and then the case is not appealed. Apparently, the people settle. If the Nevada trust also says, hey, if there's an issue, and if the Nevada trustee resigns, then this trust goes to Nevis. And then the Nevis law says that their 2-year statute applies as if the trust was formed in Nevis when it started in Nevada. So that's called a flee clause. also known as a Cuba clause, because there were trusts like this in Cuba that fled when Castro came into power. It has nothing to do with dogs and ticks. So these asset protection trusts, you can't promise they're going to work. We don't know if they're going to work. And if you do the offshore asset protection trust at the last minute, then you have a risk of being put in jail on contempt. And there have been people who have served jail sentences, particularly Mr. Lawrence, who I believe served 9 years before the court said, wait a minute, you're in there by accident. The bankruptcy court judge was wrong. Once you've been in there 1.5 to 2 years, that's proof that it's not working, that you're not going to obey the contempt order. So he should have only served 2 to 3 years instead of 9 years. But I think when he finally got out, he kept most of the assets. I wouldn't encourage the conduct. And what really infuriated the judge in the Lawrence case was apparently dishonesty by Mr. Lawrence. So let me mention, and I guess we'll do part 2 because I'm running past my hour here, so I'll answer some questions. Whenever you have a situation, look at it and decide whether you can divide up the assets and the liabilities from the exposures. So you're doing not only estate tax planning and estate planning and financial planning, but make sure that you are looking into and understand what the impact of this planning is on each spouse. And one of the things that we mention is if you are in a community property state, which is most notably includes California and Texas, then unlike Florida, where your joint assets are protected from creditors, all assets that have been brought in during the marriage, also known as community property, are subject to creditor claims. So you're a doctor in Texas, you get sued, all of your family assets can be subject to creditor claims unless you transmute out of community property treatment. So there's a lot of things to know. I'm going to go ahead and answer some questions now, and then I'm going to go have lunch with Marcia. Okay. What was the website address for laws by state? It's ACTEC. It's ACTEC. It stands for the American College of Trusts and Estate Counsel. And they have assigned different lawyers in each state to put the information on creditor protection in a very large spreadsheet. I'm not in ACTEC. I'm not affiliated with ACTEC. They probably wouldn't want me or trust me to put anything on their spreadsheet, but it's a pretty good spreadsheet. Let's see. When has the government ever been charitable? Thank you, Andy. I won't get into politics. I guess I shouldn't have said anything in the first place. Okay. With exempt assets, one, I assume that the client has to be domiciled in Florida. Yes, except as to tenancy by the entireties in real estate. So the bankruptcy code protects real estate. So if your clients live in a state that doesn't provide protection for tenancy by the entireties or doesn't even recognize tenancy by the entireties, if you buy Florida real estate, then between a married couple, it is tenancy by the entireties. And then if you have to go into bankruptcy, it will be protected under the bankruptcy code, regardless of your state law. Now, there's an Iowa Supreme Court case that came out about 2 years ago that says that the same thing generally applies for an LLC. In that case, a Florida couple set up an Iowa LLC, and they tried to argue that Florida law should apply to protect the LLC as tenants by the entireties. And the Iowa Supreme Court said, no, Iowa law applies because that's where the LLC is, so you don't have tenancy by the entireties protection. So if that case is correct, and I think there's at least a 50% chance it is, if you're in New York and you don't have tenancy by the entireties protection, then you set up a Florida LLC or a Delaware LLC to own your investments, and then at least you have a claim for tenancy by the entireties protection. because the law of the jurisdiction where the LLC is may apply. Sometimes it's better to try than to do nothing. It gives you at least something to argue about. Number two, if you have a non-qualified annuity purchased in your prior state, say New Jersey, so you have a New Jersey contract and you're now in Florida, domiciled resident, does the protection now follow? Yes, it does. Now, tenancy by the entireties under a New Jersey bank account may not be protected. I don't recall whether New Jersey recognizes tenancy by the entireties for accounts. I don't think it does. But tenancy by the entirety, if you buy a variable annuity, sometimes clients buy the variable annuity in Switzerland or Bermuda, where you can get a customized variable annuity and put customized assets in there. And believe it or not, it can be less expensive than a US-based variable annuity. So we believe that those are protected under Florida Statute Section 222 and under the law of the foreign jurisdiction where the annuity is issued. And there's a case right on point. It's the In Re Rensin, R-E-N-S-I-N decision that came out 2 or 3 years ago. It's a very interesting case. There's a YouTube video. If you can't find it, I'll send it to you, where I interviewed my friend Dennis Kleinfeld, who represented Mr. Rensin. And in that case, a Belizean trustee bought Cayman Island annuities for Mr. Rensin. Mr. Rensin didn't ask the trustee to do that. The trustee just did it. So the bankruptcy court judge said, well, I don't think the Belize trust stands up, but the annuity does stand up under Section 222. And then the creditor said, yeah, but it was a fraudulent transfer to buy them. We're in the middle of this lawsuit, and the trustee buys these annuities and puts Mr. Rensin's name on them. That was definitely a transfer to avoid creditors. And the judge said, well, it was not a transfer by Mr. Rensin. The Florida Fraudulent Transfer Act says the debtor has to make the transfer, not the creditor. And believe me, the court did not like Mr. Rensin. If you read the decision, it's a very well-written, interesting decision. We call it the Purple Hippo decision because Mr. Rensin had a website. I think the name of his company was the Purple Hippo, where people with bad credit could put things on layaway and then receive them. And the FTC didn't like the way that was working, and it became a class action suit. So it was pretty interesting. And then finally, yes, the wait was performed by Robbie Robertson, and the 50-year anniversary of the 1969 song was performed by Robbie Robertson, Ringo Starr, and as one individual said, about 20 musicians over 5 continents. It's really, really a nice rendition. Okay, as always, we welcome your questions, comments, and suggestions. I see a lot of emails here that I'm going to answer after lunch with Marcia. Have a fantastic rest of your day. Brandon and I will be keeping track of the legislation as it develops, and we'll keep you abreast of all of that.